Hello, everyone. Today we have with us Advocate Abhinav Raghuvanshi. Advocate Abhinav is an advocate on record, Supreme Court of India, who is a regular face before the Hon'ble High Court of Delhi and the Supreme Court. He specializes in banking and recovery, insolvency and bankruptcy laws, contracts and tenders, service laws, IPR and arbitration laws. He started his career as a junior associate in the chamber of the Additional Solicitor General, thereafter with the Additional Advocate General, State of Rajasthan. Today, he is the Senior Central Government Counsel at the Delhi High Court, Counsel for the State of Uttar Pradesh at the Honorable Supreme Court, Panel Counsel for the Delhi Development Authority, and further on the panel of multiple private organizations and NGOs. Recently, he has been appointed as a member on the panel of the Supreme Court Mediation Centre. We welcome you, sir.
Thank you, Ritu, for inviting me on the talk show.
Thank you.
I'm grateful to you that you have taken such a great initiative for educating young lawyers or coming generation of lawyers. Thank you for inviting me to the show.
Thank you, sir. To start with, you've been a scientist and an assistant professor before you switched to law. Tell us about your journey that inspired you to become a lawyer.
Correct. That is very true that lawyer, this litigation happens to be my second avatar, a professional second avatar. Because to start with, I never started or never dreamt of becoming a lawyer at any point of my life. I started my career as a scientist with NPL, and thereafter I was assistant professor in the Department of Physics, Delhi University for 5 years. So I never had any plan to get into the litigation or any field of law. And to be honest, I'm a first generation lawyer. I didn't have any idea about law till I post-graduated in physics. So in short, because it's a talk show, so rather than avoiding into details, in short, I'll like to tell you that it was my real life experiences and my confrontation with this law enforcement agencies that motivated me to take the field of law. In short, something happened to me in my real life wherein I was spending, as a professor, I was supposed to spend more time in the classroom, but rather I was spending more time to the courtroom. So in short, you can say that destiny brought me to this field and I became a lawyer.
How would you describe your experience in litigation so far? Who were your mentors professionally and personally through this journey?
To be honest, it has been a very pleasant surprise. It has been a pleasant surprise. Not at all the way I was told in initial days. Not at all the way I perceived based on the information which I got from my seniors or from my relatives who were a bit aware of this field basically. Because I was a first generation lawyer, I was very skeptic. Yeah, whether I'd be able to make a career out of this or not, whether I'll be able to survive even. And since I was getting salaries, so I was in a comfort zone. I never wanted to leave that comfort zone of a government job. But from that perspective, it has been a very pleasant surprise till date. It has been a mix of good experiences, bad experiences, but ultimately a feeling of satisfaction, a feeling of having established something in my own name.
During law school, had you always been drawn towards practice, or were there other dimensions that interested you?
Share many mentors when you do
Right.
that.
No problem. I'll pause it.
Now, as far as the mentors are concerned, most of my mentors in this field have been non-lawyers, to be very honest with you. In fact, I had a very short stint of 1 year as a junior with any senior advocate, basically. I worked with the Additional Advocate General for the state of Rajasthan for almost 4 to 6 months, and with the Additional Solicitor General of India, Mr. Amrin Saran, for a short period of 4 to 6 months. And that was all I worked under somebody. But yes, those exposures, those experiences gave me a quite great insight. And they've been a guiding factor throughout my career journey. But as far as the mentorship is concerned, I have been more into the Eklavya mode of learning, basically. I've been seeing a lot of seniors. I've been briefing a lot of seniors. So there have been so many senior associates, you can say senior designated lawyers, or even constitutional dignitaries like Advocate General, Solicitor Generals, who have been guiding me case to case basis. So I am so grateful to the entire fraternity which have been guiding me, and I consider each of them, all of them who have been along with me in some case or the other case as my mentors.
Right, sir. And during law school, had you always been drawn towards practice, or were there other dimensions that interested you?
Yes, for me personally, well, practice was the only thing which I meant by law. It could be very parochial definition, it could be very narrow definition, but more for me, as I told you, there was some life experiences, and I wanted to create an impact basically. I want this give what to me litigation gives me the empowerment basically. I can bring about some change. If I want to speak something and I want to get something implemented, I have a platform, I have a voice where I can raise those things and get those things implemented, though in a very little way, in a very small way, but this gives me empowerment. Litigation for me means empowerment, not just a profession. It's empowerment.
Right. You're an AOR. Could you tell us more about the institution of the AOR? What does the Supreme Court rules mention about the criteria for becoming an AOR?
That's a very right question, because when I entered into this profession, I was not aware of this institution. So there is an institution of AOR. The full form stands as Advocate on Record. Now, Supreme Court, in Supreme Court rules, this particular designation is mentioned. And for Supreme Court, pleading before Supreme Court, only these are the categories of advocate who can plead before the Supreme Court. Means, in other words, for any filing, be it a writ petition, be it a SLP or be a reply, all the pleading has to be done only by AOR. One part. Second part, as far as the eligibility is concerned, yes, under the Supreme Court rules, there is eligibility criteria that says 5 years of experience plus 1 year of internship under another AOR who is having standing of at least 10 years as an AOR. So, आपको, can I put in informal language Hindi also, or I need to be? I'll come back.
No problem, sir. If you want, you can answer the entire.
Okay, I'll come.
Yeah, answer the entire.
Yes, as far as AOR is concerned, yes, this is the institution which is defined in the Supreme Court rules. And it says that all the pleadings before the Supreme Court has to be done by an advocate on record. So everything which is filed before Supreme Court, be it SLP, be it writ petition, be it transfer petition, or any kind of pleading, it has to be done, and it can be done only by an advocate on record. And since this institution is defined under the rules of Supreme Court, obviously there is a criteria for it. There is an examination for this AOR, and the eligibility criteria is that you should have at least 5 years of experience, number one. Second, post 5 years of experience, you need to intern yourself under an AOR who is having 10 years of experience as an AOR. So second criteria is that post 5 years of qualification, you join an office of an AOR, intern there. After completion of your internship, you submit a certificate of completion before the registry. After that, you register yourself for this examination called AOR, which is again conducted by the Supreme Court itself. And the examiners are all the senior designates or the constitutional dignitaries. Even the attorney, in my time, the present Attorney General was my examiner, Venkat Ramani. So he was the examiner basically, and then there are 4 papers nowadays. They are all theoretical in nature, and since after 5 years you lose your habit of writing, ultimately you have to write, and you have to pass that exam. And passing criteria is very simple: 60%. That's all. 60% you need overall, but if you fail in any of the subjects, you are failed. So that is the criteria basically.
Got it. Could you tell us more about the role of an AOR and what are the benefits of becoming an AOR?
Role, as I told you, is basically filing, and it's not normal file. Let me tell you, Supreme Court rules itself is complicated. So what Supreme Court requires is a person who is well versed with the Supreme Court rules, thereby assists the court in the process of filing and pleading effectively. One part. Now, once you are qualified AOR, the advantage you get is that at least in the eyes of common man and in the eyes of Supreme Court registry, You are distinguished class of an advocate. I think as on date, we are only 4,000 AWARs in the country. Though we may have 3 lakhs lawyers in the entire country, but AWARs are 3 or 4,000 only. And out of this, I think 2 or 3,000 are practicing. 1,000 are very senior or they are not in practice nowadays. So that is one part. Second, since you have exclusive privilege of doing pleadings before the Supreme Court, even if you join a firm tomorrow, or if you join a chamber of a senior designate, as you know, senior cannot file his own wakalatnama. So he has to do all the pleadings through the AWAR. So that gives you an edge in terms of employment. In terms of in perks, suppose you are a counsel and somebody in AWAR. So even if you are a counsel, but you are AWAR also, so you will be compensated higher as compared to a person who is not holding an AWAR. But this stands true only for the Supreme Court. Try to understand, this examination is conducted by Supreme Court. This designation is within the Supreme Court role. So ultimately, the institution of Supreme Court is advocate on record, is confined to Supreme Court only. But that gives you an advantage. That is the advantage which we get. Third, obviously, we have our separate associations, and even in our bar meetings, you can always put in card, you can visit registry. So that advantage of registry is there with you.
Right. And since you're the Senior Central Government Counsel at the Delhi High Court, Counsel for the State of Uttar Pradesh at the Hon'ble Supreme Court, Panel Counsel for the Delhi Development Authority, Senior Counsel for Delhi Government, Central Board of India, Indirect Taxes and Customs, please guide us as to how can one apply for government panels?
Look, Ritu, as far as the applying is concerned, is very simple. From time to time, there are notifications, especially by this, if you see the income tax department, CBDT, or if you see the central government, only for the Union of India, there is no exclusive advertisement or notification. But from the time to time, you can always apply for all the PSUs, even the PSUs, all the ministries, they are from time to time giving advertisement, including banks, and ONGC, NPT, and they have set eligibility criteria. There is no uniform criteria. Each organization is having their own criteria, 5 years, 10 years. AORs also exclusively for Supreme Court. Every organization is having different panels, junior panel, senior panel, AOR panel even. So depending on your eligibility criteria, wherever you can fill your criteria, 3+ years, I guess, you can apply for all these organizations, all these panels. That is a white zone. But the rest of things, so many things works in this country. So the selection criteria is obviously obvious. Most of the people in the country.
Right.
But yes, eligibility post 3 years, there are advertisement. There are groups also. There are young lawyers who have made their groups. Every young lawyer, I suggest to join those groups in which they keep on circulating these kind of recruitment or notifications from time to time, wherein you can be aware of those notifications, and right time and right point of time you can apply for those posts.
Yeah. You're also on the panel of multiple NGOs like Aware Citizen Foundation, Netram Eye Foundation, Art Culture and Heritage Foundation, Trijya Foundation. Please tell us about them and your role in them.
It's very accurate. In fact, I'll tell you, I started the empowerment word. I started with the word empowerment. So one of the medium for getting the effective empowerment for a common mass is these NGOs. So I've been associated with the NGOs pre my lawyer avatar. Even if I was not a lawyer, when I was not a lawyer, I've been associated with NGOs. Now, what a lawyer does for an NGO, it starts with day one with the incorporation of the NGOs. Day one, we have to guide, you have to guide as a lawyer, what format of an NGO you can choose. Suppose a person or a client comes to you and he wants to incorporate an NGO. So day one, there are 3 formats of NGO in India: society, the trust, and the non-profit company. So a lawyer's role starts from incorporation of the NGO, part 1. Second, you help them in drafting their aims and objectives. Third, the most important part is the taxation part. As it is commonly known, normally whatever NGOs earn, they are not liable to be taxed. But that is not that simple, basically. For getting that exemption under income tax, we have to apply for Section 12A exemptions under IT Act, Income Tax Act. So then IT compliances are there. Post that, ATG compliances are there. It means whichever NGO is having ATG certification from the IT department, that is Income Tax Department, if they get the donation, the person who gives donation to them, his income, that part of income is exempted from the income tax. So broadly speaking, FCRA also, if you have heard about this word FCRA, Foreign Contribution Fund, so that is given by Home Ministry basically. So NGOs works on funding, if you understand. So the entire funding and taxation parts, we keep on regularly advising them. And the third part is obviously NGOs have been very instrumental in raising public voice before the Constitution Court. So all the matters of public concern, in all the matters of public concern, if you want to file in PIL, NGOs works on platform. So you can use the platform of the NGOs to get your public issues filed before the Supreme Court or the High Court, and you can have effective remedies. So that has been a limited role, you can say, or extensive role of any lawyer basically, and my specifically with the NGOs. All these NGOs I'm doing mostly these roles.
Right. So, but what kind of queries or matters do these NGOs have to face on a daily basis or regularly?
Correct. So depending on the nature of the NGO, there are NGOs which are helping old age people. There are NGOs which are helping women, especially women basically. So they want these ladies who come from the weaker section of the society or from the poor section of the society, they want effective legal aid for them. Mostly they come, they are the victims of, say, domestic violence, victims of crime, including rape and etc. So there are rehabilitation schemes. So they want that these victims should be rehabilitated. But obviously, since they are not legally literate, I say, they are literate though, but not legally literate, and you know how the government functions. So they want to involve the role of the courts in getting the right directions or the instructions from the court to these authorities so that they can get the effective redressal. So on day-to-day basis, there are NGOs which are here in the medical field also. Now, they are distributing medicines. There could be IPR issues. They are distributing some medicines which are generic. So there are pharmaceutical companies who claim the right that cannot be given, something like that. So IPR issues also we are dealing with it. So NGOs by and large are this one part. Second, if you are aware of something, some new concept called CSR, corporate social responsibility. This is a new concept which has been included in our Companies Act 2013 basically, wherein government says if a company has a turnover which is over and above this much amount, they have to compulsorily donate X percentage out of their turnover for the corporate social responsibility, that is towards the NGO. So here there is a nexus between the corporate and the social, you can say, social responsibility of a corporate basically. So again, that is our part. So we are trying to somehow procure that CSR fund, that is called CSR fund. That is another source of funds for these NGOs. So as a lawyer, you can guide them how to get this CSR fund, one part. Second, we also guide what are the schemes of the government of India, which are being run through various ministries, where NGOs are instrumental. There are schemes which are exclusively implemented with the help of the NGOs only. So we keep on guiding that since you are into this particular field of helping or say charity, kindly do, you are eligible for this scheme and you kindly apply for this scheme and get the benefit of that scheme to the downtrodden or the public person who genuinely require that. So I feel that NGOs for the last 10 years have been very instrumental in implementing the government policy at the ground level, at the root level. So somehow I'm trying to help them to effectively help them is that whatever policy decisions are taken by the government that reaches to the lowest or the weakest section of the society. This is what we are doing as a lawyer, that you can say as a pro bono, mostly pro bono.
Yeah. You mentioned donations and the income tax compliances that these NGOs need to do. Since 2020, the government has changed many rules governing donations to NGOs. How has this move affected the NGO sector, and what is your opinion on these changes?
Let me clarify one thing. There has been a lot of rumors around that the government has banned this, government has. No, they have not effectively banned any domestic kind of donation. The ban has come only in form of FCRA, foreign contribution. all those NGOs which were getting foreign contribution, and that is governed by the Home Ministry, basically, specifically Home Ministry, that has come under scrutiny. It has not banned it. It has put up new standards, new set of scrutiny, and that has been specially done by this present regime to help identify the money laundering, because you know every system has a gray part. So there are a lot of NGOs which were getting funds in the garb of donations, but actually they were donations or the part of money laundering money that was not clear. And sometimes those donations were coming to India for funding anti-government activities also. That provoked the government to have a relook onto the criteria of getting FCRA for different NGOs and all. Now let me tell you, the process is more streamlined, more clear, and I know individually, I'll not name this NGO on the show, that the person from the ministry themselves came and proposed. She's also a lady, a surgeon, eye surgeon, a soul stalwart. She's doing great job in the medical field. And they themselves came and offered FCRA. You are doing, ma'am, genuine work. You please get this FCRA without a single penny, of corruption. So it is just like saying the cash ban or the GST regime. Initially, it looks like, it's a bit tough, government has been harsh, but ultimately it is trying to streamline one part. Secondly, they are trying to scrutinize. That is true. That is true. The present regime is very curious about the source of the fund, so that it ensures, one, it is not part of money laundering. Second, that it is not used to fund anti-government activity. So the present, in my view, whatever amendments have been brought about in the realm of the FCRA is going to help these NGOs and all the NGOs basically in long run. But in short term, during the scrutiny, obviously those who are involved in the frivolous activity or the frivolous funding will be weeded out.
Right. And if I have to talk a little aside from this, can you talk about any particularly memorable case that you handled?
Yes, obviously, I have 2 or 3 memorable cases, and they all belong to my first 3 years of career. One case which I vividly remember, because that goes beyond the normal call of a lawyer, which I dealt in CAT, Central Administrative Tribunal, where we had a peculiar situation. There were 2 coordinate benches having given 2 different orders, contrary orders. One coordinate bench gives me a order, another coordinate bench stays the order, same from the same court. And this was a very special case because, again, this was something relating to harassment at workplace. That's Show Act. So there is a lady who is into grade 3, I'll not name. And that was a memorable case in the terms that I had to go against the call of the lawyer. I had to make allegation against a judge in the open court. There was a complete stunt, and opposite to me was appearing a very senior designated counsel who happens to be a relative of a justice in Delhi High Court. And even he was on the opposite side. I had to mention that matter in the interval, you can say, in the lunch to the chairman of the CAT, Justice Saeed Rafat Alam. And thereafter, it was branded by most of the members of the bar and even the members of the registry, saying that this is bench hunting and that is going to ruin my career and something like that. All kind of threats, all kind of things extended. Never says, but those things have never deterred me when I chose that. And ultimately, the best part, we got the justice. We got the justice, the bench was changed.
Wow.
And we got the lead. Despite all the work, that was one part. Second, in the commercial domain, that was my first corporate case against Reliance. Again, I was just 3 years into profession, and I was fighting a case against a big company called Reliance. And I was myself a bit perturbed, because why a person would choose a person of my standing against such a big company? That was an obvious question. And that this Reliance was not a Reliance RIL. This is Reliance Infrastructure, Anil Ambani. So this was the case, and obviously this was exciting in terms because the opposite party was a big company and they were being represented by a big firm of this country. And I was on this side, the sole one, and ultimately we won. So that was a big, you can say, encouragement for me in the first 3 years, that I also asked that person basically, who is still my client. 10 years post that, he's still my client, and he was the person who brought me to corporate litigation. So that was my first assignment, corporate assignment, a big arbitration at that point of time involving 29 crores. I vividly remember. There were ups and downs. Other party was a big corporate of this corporate house of this country, being represented by a very reputed senior designate of this country. I'll not again name him. And ultimately, against all the odds, against all the expectations, we won. And the third one, again, dates back like 9 years back. That was again a corporate case wherein I get a message at 6 p.m. in the night, 6 p.m. in the evening. There is a execution at Ahmedabad. My client is located in Delhi. Execution is in Ahmedabad, and they are a 4-star hotel basically. So there is a court bailiff along with the police to seal the hotel property. At this juncture, just like movies, you get a call that this is something. Can you stop it? And we have a time till we work through the night. We drafted through the night till 4 a.m. And then we slept at. I had one of my associate who is still my associate basically. And we didn't sleep through the night, and we worked till 4 a.m. and then 8, I think we got up, we got ready, and we rushed to the court, got the matter mentioned, and then somehow judge was pleased to allow that matter to come after the lunch. So we got that time for preparing the case basically, and effectively we were able to get the stay post lunch. And in those days there was no WhatsApp, so get it fact, police is there, the bailiff is there, and we stopped this sealing of the property. So that was also a memorable case in terms of the work which we did through the night and the kind of picture we were given basically that रात में कुछ नहीं होता, डिस्ट्रिक्ट कोर्ट में मेंशनिंग नहीं होती और ये नहीं होता, वो नहीं होता और वो अहमदाबाद है और ये दिल्ली है. This all things didn't work because I work with great conviction basically. I do my own homework. So I take inputs, but then I have my own hunches. I follow my hunches, and we thought that has been a memorable case. But in all these cases, let me tell you, out of these 3 memorable cases, 2 cases were the cases where the opposite party was represented by senior designated lawyers. But let me tell you one great part of this. It was a great learning for me in terms of those senior designated lawyers. They all appreciated my work in a very positive fashion, and it was their appreciation and encouragement which helped me to carry through this litigation journey in my life. So they were all supportive. Initially, obviously, you are on the opposite side, you have bitter experiences, you are making allegations, cross allegations are there, and then structure is involved. But then finally, I think we have to put somewhere, we have to salute our seniors also, because they are seniors in all terms. They are seniors. They know how to handle the situation. They know how to handle the judge. This is what we learn from those cases. They also know how to handle a young colleague. So I give the credit to them only for at least making me learn so many things out of those cases, apart from winning and losing. Because what I was told by one of my seniors was that a lawyer never loses. Either he wins or he learns.
True. Rightly said, sir. Right. And lately, you've been appointed as a mediator on the panel of Supreme Court Mediation Centre. How can one apply to be a mediator, and what are the criteria or qualities an individual needs to possess to take up mediation?
A very good question in the present context. Let me tell you, if you are following the trend of judiciary in the recent past, there is a trend that government as well as the judiciary is encouraging ADR, alternative dispute resolution. And ADR comprises of 3 broader things: arbitration, mediation, and conciliation. So as far as the arbitration is concerned, there is well-defined legal framework, and I do a lot of arbitration apart from the litigation, and I do most of my arbitration in Mumbai rather than in Delhi. So I have more arbitrations in Mumbai and less of arbitration in Delhi. And as far as mediation is concerned, till date it is very informal. But let me tell you, that is the advantage of mediation, because there is a constant concern by the courts and also by the government that we have to reduce the burden of the courts in terms of the pendency of the cases. So what government is trying to do is, even they have come with the new Commercial Courts Act, and that act says that there has to be compulsorily a mediation before getting into a commercial litigation. So in coming days, we are expecting that there would be a new legislation, a proper framework for mediation as in case of arbitration. So mediation is one of the most effective informal way for getting a dispute resolved. As on date, there are very limited number of cases or type of cases which can be resolved through mediation. So what I see that future belongs to ADR rather than to the litigation. So for persons of your generation, and secondly, it does not have that rigors of litigation. So in that terms also, if you see arbitration, it is all like conferencing. It is not like courtroom proceeding. Mostly I should not tell, but all my female colleagues love arbitration basically, and mediation they are very pro. And I feel that females have that edge in mediation especially because they have been gifted with certain skills where they can get intentions of the parties. They have patience to hear both the parties, and they are polite also by their conduct. I think parties confide in women more than a man. So that might be my bias, but then I see that they are more successful in mediation than any their male counterparts. Now, as far as eligibility, that is more important. As on date, what it requires is that minimum 10 years of practice. One, that you should have 10 years of practice. Post that, there is a compulsory training on the lines of international mediation, basically, and that is 40 hours of training spread over 5 days. I was trained in Delhi Judicial Academy. So post that you have a training. Thereafter, there is a compulsory requirement of completing at least 20 successful mediations as a co-mediator. So post you have attained that training, and that training is given by the seasoned international and national mediators. So after you attend that training, you have to go through that compulsory mediation basically as a co-mediator. And once you complete at least 10 successful mediation, you will get a completion certificate that you are now certified as a mediator. Thereafter, you can apply on the panels of mediators before different courts. And now, almost all the civil and commercial courts are having mediation panels, like district courts, consumer courts, even NCLT, NCDRC. They are all having Supreme Court. So they are having mediation panels wherein mediators are there on the panel as and when cases are directed by the court. All the cases are marked from the main court only, be it district court, be it high court, be it Supreme Court. All these cases are marked from the courts or by the arbitrator. These parties are sent to the mediation wherein the mediation coordinator is there. And in each district court, there is a judge in charge who is in charge of this mediation center. He has a panel, there is a coordinator, and as and when case comes, it is marked to a given mediator for reaching an amicable solution. That is the best part of the story of mediation is, apart from it being informal, solution is always going to be an amicable. Thereby, what is important is there are no chances of further appeal. You are getting my point. Since the matter has been resolved by common sense, you can say in a mediation, दोनों पार्टी ने आपसी सहमति से केस किया है तो फर्दर अपील के चांस नहीं बचते हैं. दैट इज व्हाई इट इज सो इफेक्टिव. कि अगर मीडिएशन सेटलमेंट हो जाता है तो अपील का पूरा प्रोसेस ही खत्म. हाई कोर्ट इज ओवर, सुप्रीम कोर्ट इज ओवर. So therefore, the emphasis of the MCPC, there is a committee called Mediation and Conciliation Committee in Supreme Court, MCPC. Now this committee is evolving new guidelines and policies because they feel that the best part of the story is, apart from it being informal, there is no formal rules of pleading. There is nothing which is reported to the courts. And the best part is it stops or it solves the problem from the root itself. The chances of appeal goes down because one of the conditions which is jotted down when an amicable settlement is reached between the parties is that no party shall file appeal. So I see mediation and arbitration as future of this country in dispute resolution. And eligibility criteria I've explained to you: 10 years plus training 40 hours plus successful 10 mediation, and thereafter you're on the panel. And girls have an edge.
Sorry.
Audio.
Can you shed some light on mediation and what role does a mediator play in resolving disputes? What all matters can be taken up for mediation?
Correct. As on date, by and large, commercial disputes, number one. Number two, matrimonial disputes, and certain 138 NI disputes. These are the broader categories. Any commercial dispute, any matrimonial dispute, Matrimonial dispute may involve a criminal case of 498A also. And third is 138. Now, all those cases which are earmarked for National Lok Adalat, now there's a committee, active committee under the aegis of Supreme Court, which is deciding more category of cases. Commercial, when I say commercial, that includes every NCLT, NCLAT, DRT, DRAT, banking, insolvency, everything. Right? In DRT also, we have OTS kind of proposals. It is already there, but we don't involve a mediation as a process. This is called OTS, one-time settlement. Like you are a borrower and there is a bank, there is some outstanding dues, you cannot pay. So there is some settlement. So that is informal. Mediation would be a formal settlement. So in short, commercial disputes of every nature, matrimony, and 138 NI. Small matters like traffic challan and everything is taken care by the Lok Adalat. So maybe in coming time, they will increase more scope on certain aspect of criminal litigation also. But as on date, these are the broader categories of matters which fall under the mediation.
Right.
And they comprise more than 65% of the litigation in the court.
Oh.
Civil dispute, matrimonial dispute.
Wow. And what would you suggest to our new graduates looking to practice at the Supreme Court? Should they start their practice at the lower court first?
This is a good question. I don't have any thumb rule answer, to be very honest with you. I started with the Supreme Court, but it all depends where you are actually and what is your future. There is no thumb rule for starting practice. And let me tell you, there is no great thing about starting from Supreme Court, because one thing you should realize, the jurisdiction, the pros and cons of each of the court. They are something which is very exclusive to the district courts or the trial courts. Trials are never conducted in Supreme Court or the High Court, unless until you are on the original side of the High Court, where only 4 or 5 High Courts are having original jurisdiction. So apart from these original side, all the High Courts are having appellate side only. Now on the appellate side, you never see the trial. So if you are more interested, and let me tell you, which is saying also now I realize at this juncture, trial is the core crux of the matter. Where it is your baby. You can conceive it the way you want, you can make it or break it. You have more flexibility and more learning at a trial stage than at the appellate stage. Appellate stage, you have a limited jurisdiction more on the question of law, not on the fact. And again, Supreme Court, 136 SLP, which you might be hearing recently. Least chances. This, you know what is the success ratio of SLP normally in terms of percentage? 99% or 98.7% SLPs get dismissed. Only 1% SLPs are admitted. So you may be taking 1 month, 2 months in drafting an SLP in 5 volumes, and it takes 2 minutes to just hear that word called dismissed. Gone. So you have not learned any effectively. So as far as the learning is concerned and flavor is concerned, but I'll prefer you go take a mixed route, like High Court and District Court. In the cities where you have High Courts and District Courts like Delhi, Kolkata, say Mumbai, Ernakulam, you have this advantage, Allahabad. So you can take a mixed route. For every small relief at District Court, you can reach High Court. So you can keep chucking these 2 courts together and you can have great learning. Because you need to be master of fact first in your initial stages of learning, in your initial stages of career. You are not supposed, even the client who is hiring a 3 years of experience or 5 experience of a lawyer does not expect a legal luminary coming out of you. He expects that at least you should be master of the fact that you can brief the court in the legal jargon properly, one part. In case you are required to brief a senior designate or a senior lawyer, senior associate, you can brief him effectively in the legal language. You should be master of the fact, and that is what also judges expect when you are in your first initial 3-5 years. They clearly say there are instances, there are incidences which I have myself witnessed when they are young lawyers. I faced also. Judges clearly say, "Bhai, you are a young fresher. I do know that you might not be well versed with the law part, but at least ये तो मालूम हो किसके लिए आप खड़े हो रहे हो, किस तरफ खड़े हो, रिलीफ क्या है आपकी, प्रेयर क्या है, प्रोसेस क्या है, प्रोसीजर क्या है." So this process, procedure, the factual master is exclusively part of trials. And that gives you confidence before Supreme Court also. Because I had a very different route. I started from Supreme Court, came to High Court. Those clients brought me to High Court, and thereafter I moved to tribunals mostly. I still don't go most to the district court, but I'm going to the tribunals. So my suggestion is that there is no thumb rule. Number one, it all depends what you actually want out of your career, basically. You want to become a good trial lawyer. As far as the money is concerned, let me tell you, because that is one of the biggest questions which haunts the mind of all the investors. Don't be under any dilemma that trial courts have less money. You can make more money than Supreme Court in trial court. So as far as the money is concerned, as far as the exposure is concerned, no Supreme Court lawyer can bet a trial court lawyer who will was the trial. Let me tell you. If you are a master of trial, you can be a leader of society also. You know when the IO has to be called. What is the time when all the prisoners are brought from the prison to a court premises? What is the time when they are produced before MM? Which MM is authorized to direct which SHO? Who is the DCP of a region who has to be contacted when there is some kind of X kind of dispute and a Y kind of crime? So if you are sitting in a Supreme Court, say in a High Court, you are not aware of the grassroots reality. So my strong suggestion, although I can only advise, would be to keep checking at two places like High Court and District Court. Or akin to High Court, there are something called tribunals. I like to emphasize on tribunals here. If you give me 2 minutes, because we should now the younger generation has to look beyond two things: the traditional courts and the traditional areas of practice. We have to look beyond the High Court, Supreme Court, and even District Court. There are something called tribunals, and tribunals are more than the District Court and having the same flavor of High Court but less than High Court. Now, if you give me time, I can mark like DRT, DRAT, CAT, CAT, NCDRC, TD, SAT. There are so many tribunals which the most of the young person do not know. They are not aware during their law school. And there you can make a big name also, big money also. There is no formal rule of pleading even. Less than High Court, less than District Court. But flavor of Supreme Court and exclusive powers. So you have to look beyond traditional courts like District Court, High Court, सबने सुना है. उसके beyond सोचिए, tribunals में जाइए. CAT सर्विस मैटर के लिए होता है, DRT होता है बैंकिंग इश्यूज के लिए, NCLT होती है कंपनी सैट, NGT होता है इन्वॉल्वमेंट के लिए, TD सैट होता है टेलीकॉम के लिए. तो ऐसे ही IRDA का SAB, SAT, ED courts, Enforcement Directorate Special Court, CBI courts, they have different flavor. Go to those courts and trust me, you'll enjoy it. You'll feel a different flavor. One part. Second part, try to look beyond the traditional areas of practice, like the new areas of practice, like you see these days, more of digital transactions are coming. Online gaming is coming. OTT platforms, there are a lot of issues in gray zone. We are not having regulations as on date to regulate the cryptocurrency, the cyberspace, OTT regime. We don't have censor bodies as in case of movies or cinemas we have. We don't have any OTT platform regulation. So these are the coming issues. In coming time, they will become more and more prominent. There are more disputes relating to intellectual property. There is something called IPAB, Intellectual Property Appellate Board. Then there are trademark office, patent office. So here are the new tribunals or new areas of practice where you can make yourself expert and you can excel there. And all the appeals finally will come to either High Court or Supreme Court. So they are the places, small, not much crowded, but having exclusive expertise, where I think the young generation has an edge. They can make a distinct reputation of themselves and make a money also.
Right. And sir, since you have such a vast experience in this field, so on behalf of our aspirants and students, can I ask you if you're currently hiring interns or juniors, and if so, then how can we apply?
It's an ongoing process. I think as on date, to be honest, I've not been hiring any interns. We don't hire interns as a principle of policy because we don't want any careless people in our office, because unfortunately in North India, I have not seen any serious interns till date. Totally non-serious kind of people are coming. So, and we don't appreciate that. I especially don't appreciate that. But yes, juniors, we do hire. And I guess I think my junior associate would be in better position to tell me. But at least as on date, if you are asking, yes, we need some juniors. Interns, I think my admin will be in better position to tell you whether we need interns. But on a regular basis, we don't hire interns.
Okay.
With
Do
interns,
you
we
have a
don't get.
domain name, sir, or a website that we can
Yes,
log in?
no, I have a email ID basically, an official email ID, wherein you can always send your resume and ask for internship or juniorship.
All right.
We always welcome the young people who are full of energy and they're actually enthusiastic about learning. More go beyond the myths, go beyond the normal things. And if you ask me few tips for the new generation, I'll tell you, have a very broad mindset for litigation especially. You have to think beyond the law. And I always say to all my juniors, if you want to become a lawyer, please don't read law.
Mm.
You don't read law for next 2 years. Don't read law. No English. Because you have to learn the practical aspects of law. You need to understand the ecosystem. What unfortunately the curriculum tells us in 5 years or 3 years is that statute, that's all. ये कानून वो कानून CVR substantive law procedural law ये you forget that there is a place where we have to apply this law. You have to understand the equal. There is a registry. There is a registry which is very important aspect of every court.
Right.
And as a lawyer, you have to interact on day-to-day basis with that registry, and that fetches you the new client. Let me tell you, that gives you favor in a lawyer's chamber. If you are well versed with the registry work, every senior designate will ask you, please Abhinav mera kaam kara do, please Rutu mera ye kaam kara do. They will request you. I've seen people talking on social media platforms like LinkedIn that they don't get paid. I am ready to pay. Please do my work. I open challenge. I can pay them 2 lakhs of rupees. Please do it. I don't have to pay from my pocket. Try to understand. That has to be paid from the client side. But you should have that requisite skill and that energy to get it done. So I'm not blaming them, but I do understand that most of them are confused that they don't know what they ought to know in their initial 3 to 5 years. So my advice would be, broadly speaking, please broaden your mental horizon. Think in long-term perspective, because there is no age of retirement. You'll be arguing through your life, but you need to have certain preparation, certain minimum skill set. So try to spend your time in acquiring those skill set in your initial years. Try to broaden your knowledge base, because in litigation you'll come across every broader spectrum of cases. I deal with at least 7 industries. I have no financial background, but because of them only, because recently I've been going to the board of the companies also. So I did my finance course at this age. At age of 40, I went to do my executive program in finance from IIM Ahmedabad. Because to understand those financial jargons, because I was defending most of these clients in their financial crime. I was visiting EDs, I was doing the willful default case. So I'm trying to tell you, you should not stop learning. The message is you have to learn. And in the process, you have to unlearn those bad habits which you've developed in the, say, student life, or you have to go beyond the myths which you hear. And I can assure you, and I guarantee you that you'll have a very positive and a very wonderful litigation career.
Right. So thank you so much. You've been really gracious with your time and guidance. We really appreciate it. Thank you so much for shedding all these guidelines to us. Thank you so much, sir.
Thank you, Ritu. I hope that this would be of some use to the young generation.
Definitely.
And my only motive is to guide them to make their career and take their career as a litigation.
Sure, sir. Thank you so much.
Thank you, Ritu. Thank you once again.